Good morning. I'll reconvene the hearing panel for the proposed district plan. The issues being considered are for hearing stream 6, which are contaminated land and soil, noise, public access and subdivision. We'll start off this morning an explanation of the 42A report on subdivision. I will hand over to the property group. Thank you.
And before we do, there was a slight hiccup in receiving supplementary evidence, and I was unable to actually access my machine until this morning to get it. And that's what I put in terms of copies, the supplementary evidence that popped up on machines yesterday. Have you got that?
Is that what Francis was printing this morning?
No.
Or is it something else?
Yeah.
Supplementary evidence from the property
Yeah.
that Victoria sent through.
Yeah. So we'll need some briefing in terms of what's in that, please. So if we're dealing with subdivision first.
Good morning. I'm the Section 42A author for the subdivision chapter of the proposed district plan. I can talk you through my supplementary evidence. I'll take my Section 42A report as read, and my supplementary will just touch on any changes that I've made as a consequence of evidence received from submitters. So myself and Mishka Banhidi, we have done a joint supplementary evidence on the basis that public access and subdivision have got intrinsic links. We received evidence relevant to subdivision and public access from NZTA, Silver Fern Farms, Clark Fortune MacDonald and Associates, the Department of Conservation, Southland Federated Farmers, and Transpower. In relation to NZTA and Silver Fern Farms, the recommendations made in both the subdivision and public access reports were supported by these submitters, and they have no outstanding issues.
Sorry, which ones were they?
NZTA and Silver Fern Farms Limited.
Right.
In relation to the Department of Conservation, we had support for multiple provisions, the entirety of the public access chapter, subdivision objective 4, subdivision policy 18, and the changes proposed in the 42A report, providing clarity around which rules were applicable to subdivision if certain permitted conditions were not met. Outstanding areas of disagreement were relating to Rule 1 and Rule 4, and the description of significant natural areas. The Department of Conservation requested that the significant natural areas also included reference to unmapped areas and highly mobile fauna.
Now, what I've learned doing decisions is that I need to make notes in your 42A report. So if you're able to tell us where they are in the 42A report, so I can put it there as well.
Yep. Okay. Just give me one moment. Okay, so page 48 of the Section 42A report is the start of the submissions and assessment on subdivision rule 1. And this is managing boundary adjustments. So in that rule, one of the permitted conditions, or one of the rule conditions, is that the sites subject to the boundary adjustment cannot contain a significant natural area. And DOC requested that significant natural area reference was extended to include unmapped areas and areas of highly mobile fauna. I have partially rejected this request on the basis that the definition of significant natural area also includes unmapped areas, so it's not necessary to include that additional wording in the rule. DOC have highlighted that through the transport section 42A hearing stream, that highly mobile fauna was included in the reference to significant natural area. So for consistency, I've included it here. However, these areas need to be mapped, and currently they're not.
So this is another one where you've also highlighted that we should defer making a decision until the hearing stream on that. And there's a few more of those popping up through all the reports that we're dealing with today. So who was keeping track of all these ones that have been deferred? And will the submitters have the opportunity of actually speaking at that hearing?
I believe so, yes. So we're using the Spoken software, which you're aware of, and through that software you can provide comments and a recommendation against each submission point. So as we're moving through our hearing streams, we're updating that software to either say that this point's been deferred, in which case it gets moved to that hearing stream, Appendix B, and then also the wrap-up hearing at the end we'll use the software as a mechanism, as a catch-all. So anything that either hasn't been addressed or is sort of been deferred and not picked up will show up and then be addressed at the wrap-up hearing. But everything that's sort of related, so the main ones that you would have seen multiple times is natural hazards and biodiversity. So the biodiversity hearing stream will cover issues such as this Department of Conservation submission, which they have submitted on throughout the plan, and will be notified through the biodiversity hearing that it will come up again at that point. We've obviously had to make note of it in our 42A reports, and I guess we have advised to for you not to make a final decision on it until you've heard the biodiversity hearing, in case things do change. So at this point in time, this is the recommendation, but our advice is to reserve final judgment until we've been through that entire hearing stream.
So it's important to avoid confusion for submitters and for us in terms of issuing decisions, that a submission point only appears on one decision. And there's an example in the ones we're hearing today where, as part of temporary activities for helicopters, it said wait for the noise report, and the noise reports come up. I've got a placeholder sitting in the temporary activities decision, so after the hearing today we'll be going back to that and inserting it back there, rather than duplicating it and coming up in more than one place. But some that are appearing in virtually every report, and you've got FENS, you've got Environment Southland, we're heading towards, in our thinking, of actually issuing a decision number 2. Decision number 1 will be the framework for decision making. Decision number 2 will be what I term loosely as the repetitive submissions that appear in every one. So we'll deal with them once in a standalone decision rather than in every report. So I just wanted to share that with you today, and if it's not going to work, it'd be good to know that, but also that it's part of the public record that that's where our thinking lies.
Yeah, I think that would be a good approach. My only qualifier would just be if you've got certain submissions that, depending on the zoning that they're in, might have a different outcome. But there's nothing to say that you couldn't just address that through that second decision.
I have a.
Yeah.
Oh, sorry. Do you want to
No.
continue with it? I just have a question. So that would, on page 40, sub P7, 9, 175, 9, encouraging subdivision layout and orientation which supports energy efficiency, including active travel, walking and cycling, and conservation for future land users. But in your assessment, you have left that out. So you don't consider the inclusion of clause 9 as necessary. I just wondered if that's something that we would be looking at the ECO.
Mm-hmm.
So what page are you on?
Page 40.
Oh, okay, so I have said that in relation to active travel, I consider that clause 5 of the policy adequately encourages active travel, and as such do not consider that an additional inclusion is necessary. So clause 5 says that in urban areas require access to and provision for walking and cycling infrastructure through subdivision and subdivision design. So I haven't included it as an addition on the basis that I consider that point 5 of the policy discusses walking and cycling infrastructure.
But it doesn't discuss conservation for future land uses. That I feel that is quite important.
So that's already there.
No, it hasn't. It isn't.
Yeah, it is there. Sorry, it is there at point 9. So basically, NZTA wanted just the inclusion. So point 9 is already in the policy, and NZTA wanted to include active travel, walking and cycling in that clause. And I've said that that's not necessary because clause 5 covers it, but clause 9 is still, clause 9 of the policy still says encouraging subdivision layout and orientation which supports energy efficiency and conservation for future land uses.
Oh, okay.
So it is in there, yeah.
It is.
Yeah,
Thank you.
so I was just making sure, I just didn't think it needed to be repeated in clause 9 as it's also in clause 5.
Perfect.
Okay, so back to your Rule 1 discussion. Sorry
Yes.
to have interrupted.
No, that's okay. Okay. So yes, as we were saying, there are issues that are popping up through the chapters, and references to significant natural areas, highly mobile fauna is reoccurring, and we do recommend that you reserve any final decision making for the biodiversity hearing. Okay. Federated farmers have provided supplementary evidence. They support the recommendations in the 42A report in relation to the definition of access strip and wetlands, subdivision objective 5, policy 13, rule 5 and standard 1. The outstanding areas of disagreement, those relating to public access, I'll leave for Mishka van Heede to address. In relation to subdivision, we have outstanding discussions in relation to objective 4. I'll just find the page number for you in the 42A. Okay. Okay, so page 33 of the 42A has the assessment on objective 4 of the subdivision chapter. So Federated Farmers highlighted that the phrase physical and natural resources, as currently notified in the policy, did not align with the definition that we have in the proposed district plan and also higher order documents. I have reviewed the definitions and sort of tried to understand exactly what Federated Farmers were suggesting with their changes. And it was basically the order of the wording. So whilst the policy was, the outcome the policy was seeking was the same, they just wanted to reorder the wording so that it reflected how it was defined in the plan. And therefore I've supported that change. Federated Farmers also raised...
Well, while you're on objective 4 on page 33,
Yep.
you've recommended a change to number 2 in that. And number 2 deals with iwi values, and I can understand how subdivision is designed to protect wāhi tapu areas from inappropriate, so access. I cannot comprehend how subdivision can maintain and enhance Mahinga Kai values. If you could explain that, would be greatly appreciated.
Yeah. So...
It's not access, it's values.
Yeah, so you can enhance values through a multitude of things. So in terms of subdivision, in my opinion, enhancing Mahinga Kai values may involve protecting or restoring ecosystems, you can improve water quality, you can restore habitats, and you can promote sustainable land use. So in my opinion, you can maintain or enhance Mahinga Kai values through subdivision design.
Is using the word enhance appropriate? Could you not just leave it at maintain?
I think we have a responsibility under Part 2 of the RMA to maintain and enhance iwi values if we can. It's not... if the opportunity is there, then the policy is encouraging it. We either maintain or we enhance.
So when a subdivision consent is being prepared by a surveyor, how do they determine if there are Mahinga Kai values that might be relevant?
It would depend on the site characteristics. So if they have a waterway through the site, if they have a wetland, if it's a large subdivision development and there's therefore stormwater design provision that needs to be considered, that would then have a knock-on effect to waterways. So it is a case-by-case basis in terms of actually what subdivision you're undertaking. A 2-lot infill subdivision in the middle of town is going to have different considerations than a large greenfield development that has a stream running through it.
So whenever there's a waterway or wetland, will that require consultation with iwi?
Not necessarily. It would depend on the future land use, the density requirements, the location of boundaries and proximity to the waterway, if there's potential for stormwater to be directed into the stream.
It's a conversation that no doubt will be further delved into as part of our hearings coming up later.
So in relation to Objective 1, I have accepted Federated Farmers' proposed amendments in relation to natural and physical, what did I say? I think it's natural and physical resources, but I have not accepted their proposed changes in relation to Clause 2. The other component of the Federated Farmers submission related to Rule 1 again and the boundary adjustments and the inclusion or exclusion of land that contains outstanding natural landscapes, outstanding natural features and significant natural areas. There is disagreement, I think, between myself and a few submitters in relation to the potential effects of a boundary adjustment. I fully recognise that boundary adjustments can and often are a means of land succession and facilitating farm sales and the like, but they can have adverse impacts depending on their design and actual, the intended outcome. Just from my experience, I've seen boundary adjustment applications that are not simple land transactions. They can enable adverse effects in terms of site sizes, and I do think that if sites contain outstanding natural landscapes and features or significant natural areas, then that does need to be considered through an application. I do note that just because the boundary adjustments are controlled activities, and if you are proposing a subdivision with a site that contains an ONL or an ONF or an SNA, then it is proposed to be a discretionary activity. I do not consider that the matters of control as listed in the Rule 1 provide council with enough comfort that they can address potential issues on these Section 6 matters. So I've not made any further amendments in that respect to Rule 1.
Isn't one of the points they raise that if there isn't a boundary line going through one of these significant areas, then provided you're complying with the minimum lot size, there will be no adverse effects on the significant areas. What's your response to that?
My response is that I don't think that is necessarily covering all potential impacts. Just to say that the boundary isn't passing through the area. I think there's still potential for other issues, and it could be reverse sensitivity. It could be knock-on effects of land uses that are being enabled. In my opinion, I just don't think a controlled activity subdivision for a site that contains a Section 6 matter of significance or area of significance is appropriate. I think the council needs to retain or reserve some form of control to manage those subdivision type activities. It doesn't mean that you cannot subdivide with a site that contains these things. It just means that through an application it needs to be addressed. It doesn't mean that you need to have an ecologist or a landscape architect in every single situation. It just gives council the ability to ask those further questions if necessary.
I guess the other point is that it requires a consent in any case. It's just a matter of whether it's a controlled activity or discretionary. Now, the thought I had was that could it be a restricted discretionary activity? So that if there's a particular feature that is what's triggered it, rather than having discretionary that can pick up anything, why not focus on the issue at hand in terms of a restricted discretionary?
Yep, okay. That would require re-looking at Rule 1 and providing a sort of sliding scale such that, and maybe a sliding scale so that if you did trigger, you'd need to meet everything else in terms of qualifying for a boundary adjustment, i.e. minimum lot size, etc. And then if the only remaining aspect was that the boundary adjustment or the area of land did include those matters, you could be restricted discretionary, restricted to that. I think that is a potential compromise, yes. I would just want to double check to make sure that it's still aligned with the other rule managing subdivisions of those sites, which is currently discretionary.
And if you can come back to us today on that, would be great.
Today? Okay.
Yep. Thank you.
Okay. So moving on to the supplementary evidence from Transpower. So Transpower have supported recommendations in the Section 42A report in relation to the new rule enabling subdivisions for network utilities, subdivision objective 4, and policy PA P5 of the public access chapter. The outstanding matters of disagreement were in relation to subdivision policy 3 and Transpower's request for a separate policy. In terms of where this is in the 42A report, it is page 36 of the 42A report. So Transpower have highlighted policies 10 and 11 of the MPS ET, which is the MPS for electricity transmission. Their evidence highlighted the wording used in those policies and some case law in relation to how prescriptive those policies are. They direct decision makers to avoid adverse effects on the national grid and to discourage any type of land use activities that may adversely affect the national grid. In order to do this, we have there is the National Grid subdivision corridor and the National Grid subdivision yard. So the corridor is slightly wider than the yard, and I have proposed a rule managing subdivisions that are located within the corridor. I have made, okay, I'll move on to, there's the rule and the policy. So in my 42A report, I'd referenced that policy 3 and policy 5 were sufficient to protect Transpower's asset. In their opinion, they would like a standalone policy on the basis that they now have a standalone rule and that the national direction is somewhat stronger than the policies that we have in the plan. This is on the basis that the policies currently in the plan that I was relying on have the possibility of avoid, manage or mitigate, whereas Transpower have highlighted that the MPSET is much stronger in terms of avoiding activities within that space. So on this basis, I am comfortable with the wording proposed by Transpower for a new policy, which is to avoid subdivision in the national grid corridor where future activities may result in adverse effects on the national grid. This wording does align with those national policies in the MPS, and it also aligns with the proposed rule, which if you cannot meet in terms of providing an area for activity outside of the national grid, it is a non-compliant activity. So the policy proposed now corresponds with the activity status of the rule if you cannot meet the permitted condition or the condition of the rule, which leads us on to the new rule, which is discussed at page . Okay, so from about page 17 of the section 42A report. So this is in response to Transpower seeking a new rule to manage subdivision within the national grid. So as recommended, a subdivision needed to show a building platform on its subdivision design scheme plan, locating sensitive activities, so residential units, for example, outside of the National Grid yard. Transpower have submitted, they're in support of the inclusion of the rule. However, they requested a few amendments relating to clause 1 and a few of the matters of discretion. So I have made some minor amendments to the rule, and it was actually in conjunction with some further evidence received from Clark Fortune, which I'll also talk through after Transpower, to try and make the rule a little bit more workable in terms of its application and considering what is necessary for applicants to demonstrate. So whilst Transpower have proposed building platforms, I have changed the wording slightly such that an applicant just needs to demonstrate that they can locate a building outside of the National Grid yard. And whilst this can be implemented via a building platform scenario, there may also be other mechanisms that are appropriate to recognise this. For example, no build areas, which in my opinion is just a bit more workable than a building platform. Once you've got a building platform in place on a title, everything needs to be within the building platform. Whereas if you recognise and highlight no build areas, it just gives a little bit more flexibility for applicants in terms of, or future landowners in terms of where they'd like to build, etc. Okay.
Just, I'd be interested in an explanation. There's a number of submitters who have asked for rules, and in the case of the one from Transpower, they've asked for additions to matters of discretion. So my understanding is that when a consent comes in, the matters that are had regard to and for which conditions can be put on are restricted to the matters of discretion. Is that right?
Yes.
Okay. So how can the outcome of any consultation with Transpower be a matter of discretion? It's a process issue, not something you can put a condition on.
The matters of discretion don't dictate. You don't have to have a condition on a consent based off a matter of discretion. So the matters of discretion are areas that the decision makers will and can either ask questions on in terms of requests for further information, place conditions on consent if they deem necessary, or as part of the assessment matters, or the matters of assessment that they can look at. So just because it's listed as a matter of discretion doesn't mean that there will be a corresponding condition on this. I have checked the inclusion of that as a matter of discretion with Anderson Lloyd. My initial concerns were around whether or not it could be assumed or preempted that would correlate to requiring an affected party approval. So our discussion was that given that the wording is the outcome of any consultation, that suggests that it's more a discretionary matter. So either the decision maker can use their discretion whether or not to request that the applicant consult with Transpower. We also discussed the possibility of changing the word consultation and implementing the word comments, which may soften it more slightly in terms of it's not necessarily a direction that you have to go and consult with them. So I think the outcome of any, that word any, is quite important in terms of making that matter of discretion discretionary. In terms of its implementation. And consultation, I didn't make the change because I do think that consultation and comments, they are similar in a way. It doesn't say approval, it says consultation. So, yeah, in my opinion, it doesn't mean you have to get affected party approval from Transpower, and it doesn't mean that you have to consult with Transpower. However, it gives the decision maker the option to rely on this matter of discretion to request that the applicant provide consultation comments from Transpower.
Thank you for working through what I'd been thinking. Likewise, I thought is the word consultation actually the correct word. So the explanation you've given is great. Thank you.
Thank you. Okay. So yes, you'll see in Appendix 1 of the subdivision chapter, Rule 12 is this rule that we're currently discussing, so subdivision within the national grid. And I have made minor amendments to the matters of discretion based on the evidence provided by Transpower.
Where does that flag the potential for something like no build areas, which I agree is a far better technique than putting building platforms?
Yep, so matter of discretion 1, it's the nature of the consent notice or other mechanism proposed to ensure. And then I've actually removed the word platforms to ensure buildings are located outside of the national grid yard. I just think it's a little bit more workable. Okay, so finally, I'll address the evidence received from Clark Fortune McDonald's and Associates. So in relation to support for the Section 42A report, we were in agreement on recommendations for Subdivision Policy 8, the submissions in relation to infrastructure and financial contributions, the sliding scale approach to the general residential zone minimum lot size, policies 10, 11, and 15, and Rule 3. I'll just work through the matters of disagreement or outstanding issues. So the first one was in relation to minimum lot sizes and the non-complying activity status in relation to the large lot residential zone and the settlement zone. Clark Fortune put forward a proposal that we could look at providing a discretionary activity status for minimum lot sizes that achieve more than 87.5% of the...
Whereabouts in your 42A?
Oh, yeah, okay. This will be... Towards the end of the report, we'll be looking at the standards. Page 58. Okay, so I had amended Standard 1 to reflect the density recommendations in the general residential zone. So originally, the lot or the density in the general residential zone was 400 metres squared, and through the residential hearing stream 4, we discussed how lot sizes between 350 and 400 could have a discretionary activity status. That was on the basis that a lot of the general residential zone is existing development, and we want to encourage infill where possible. So Clark Fortune have requested that we have a similar approach to the large lot residential zone and the settlement zone in relation to minimum lot size. However, in relation to the large lot residential zone, most of this area in the district has been upzoned from rural, and therefore it's greenfield development. So in my opinion, there isn't really a need or a necessity to allow for lot sizes less than that proposed in the plan, given that this is a new zone. I also want to highlight that in the large lot residential zone, that 2,000 metres squared is a minimum, given that it is greenfield development and there'll be site constraints in terms of topography wastewater treatment. I anticipate that actually the lot sizes in the large lot residential will be larger than that. So I don't think it is necessary to include provision for a smaller lot size in that zone. In relation to the settlement zone, though, however, I acknowledge that through the rural hearing stream, which seems like a really long time ago now, we did highlight that the settlement zones are quite different in their lot sizes. They've developed quite organically. There's a lot of quarter acre sites, and therefore we allowed, or I recommended, a more flexible approach in the settlement zone with the ability to have a density of 1,000 metres squared. On the proviso that consents were obtained, which addressed hazards and wastewater disposal. So I have recommended a similar approach to subdivision standard 1 to align with the density approach in the settlement zone. Clark Fortune, McDonald and Associates agreed with the inclusion of the rule enabling deamalgamation under section 226 of the RMA. They just had a minor amendment proposal in relation to existing buildings on site and how new boundaries address them. So previously the condition was that existing buildings needed to meet all site standards in terms of bulk and location. This has just been slightly amended such that new boundaries, buildings are required to meet the site bulk and location standards in relation to new boundaries. This is just to ensure that we don't have buildings too close to boundaries with the potential for shadowing. So I have accepted their recommendations in relation to subdivision rule 5, which is page 27 of the section 42A. So the new additional rule for section 226 certificates. So I've just made a minor amendment, which is in appendix 1 of the supplementary. Clark Fortune raised issue with the proposed amendments to policy 7, which is on page 40 of the section 42A. So I had proposed amendments in relation to the management of stormwater and subdivision design. Clark Fortune seek that the reference to stormwater is removed, given that there are other policies in such as the bylaw which manage stormwater detailed design. My response is that this policy is around feasibility and development and what we can encourage or ensure at the time of resource consent. It's not requiring that detailed stormwater design is provided at resource consent stage. I understand that can incur undue costs, but we still have a responsibility to ensure that the stormwater from developments can be managed, and we should not be approving, or we should at least be investigating potential for adverse effects in relation to flooding and stormwater design.
Sorry to interrupt there. I see paragraph 180 they oppose as rainwater capture is covered by the bylaw is the only thing I can see reference in paragraph 180 to that policy from Clark Fortune.
Yeah, That's correct, yes.
You were talking about removing reference to stormwater, was it?
Yes, so Clark Fortune would like clause 10 of that policy removed, which is ensuring that subdivision design provides for the treatment and safe disposal of stormwater that does not result in increased flooding and erosion risk. So in my opinion, subdivision developments must demonstrate feasibility at resource consenting stage. The policy requires consideration of a subdivision design which provides for the treatment and safe disposal of stormwater that does not result in increased flooding and erosion risk. It does not necessarily require detailed design of the infrastructure at that point.
I guess what you've flagged, or what comes to mind, and it's really arising from earlier hearings that we've had, and that's your approach to overland flows. And how can I best describe it? When we get a heavy rain here in town, we don't have areas of flooding, but we have areas where water is flowing down through the lower lying land into the property below and moving off, and it doesn't actually stay there. And as it moves through, it has the potential to cause damage in terms of undermining structures and digging away at ground, and in the case of my property of killing the plants that happen to be in slightly wetter ground as a result. So how do you think the plan should be approaching and dealing with consideration of overland flows through the subdivision process?
So this policy and the inclusion of this clause in the policy is a mechanism to enable a decision maker to question what the subdivision developer is proposing in terms of their stormwater management, which would and can cover overland flow paths. There are aspects of sort of ensuring that pre-development and post-development stormwater flows are neutral. But if we just leave it to the bylaw and do not consider it in these policies, then there's an aspect of it being too late by the time we get to the bylaw.
So should overland flows actually be appearing explicitly in the policy framework to draw attention to it?
Potentially. I mean, we've got the safe disposal of stormwater, which would, stormwater would be all-encompassing for overland flow paths. And we've also got, I think there's policies around hazards as well. Let's just check that policy.
The way I view disposal of stormwater is all the stuff that's coming off my roof. How am I disposing of it? Whereas overland flow is something of a completely different character that is what happens to the water when it lands on the ground. Not necessarily on concrete areas, but when you look at what happened in Auckland last year, a lot of the damage that they had was caused by overland flows that were actually causing flooding further down. And we're aware of some cases in Nelson as well where the overland flows caused more damage than the flooding. Roads getting washed out and the like.
Yes, it may be prudent that we specifically reference it. I will review the submissions in terms of scope to ensure that we have the scope to do that. I'm pretty sure from memory that we do. We've got lots of submissions from Environment Southland about overland flow paths. I'll just have a look, if you don't mind, through the policy framework and see where it fits. But yeah, so on that basis, I have rejected the point from Clark Fortune because I do think it's important that we address this at subdivision stage. Clark Fortune have raised comments in relation to Rule 1. I've already touched on them in relation to the discussion from Federated Farmers. So that was the issues around ONLs and ONFs and SNAs and how they're dealt with with boundary adjustments. So on the basis that I'm going to reflect on that and come back to you, that ties in nicely with that. The other point that Clark Fortune raised in relation to the boundary adjustment aspect was to do with lot size, and if you are undertaking a boundary adjustment with a lot that is already undersized, as written and recommended, that would mean that you wouldn't qualify as a boundary adjustment. So I've just slightly tweaked the wording to enable that boundary adjustment to go ahead so long as you didn't increase or exacerbate the non-compliance. So a sort of practicality point there. Okay. Clark Fortune do not support the non-complying activity status for subdivision within the Mataura River floodway. Now this is on page 58 of the 42A. So NZTA were in support of the rule, and Clark Fortune further submitted saying that subdivision in itself has no risks to infrastructure within a flood zone. In my opinion, the Mataura River floodway is a significant hazard area and subdivision should be discouraged. The activity status is proportionate to this. In general, and consistent with the wider drafting style of the PDP, activities which should be avoided have a non-complying activity status. As we've discussed many times, if a subdivision needed to occur within the Mataura River floodway for whatever reason, and those reasons didn't result in a potential exacerbation of the flooding or result in the ability to increase a land use intensity within the floodway, then the pathway is there for it to obtain consent. But in general, considering the significant risk of that floodway, and this is just the Mataura River floodway, I continue to support the non-compliant activity status for that rule.
There was another reason in its scope. The further submission has actually gone further than the original submission. The original submission just says I support, and therefore a further submitter cannot ask for a change.
Cool. And the final point from Clark Fortune, which again I have discussed briefly in terms of Transpower, was in relation to that subdivision within the National Grid corridor. So Clark Fortune actually picked up on they advised that there are already higher order documents that manage activities in proximity to the National Grid corridor. So they don't consider that it's necessary to have a specific rule requiring building platforms. So in response to that and taking that on board, I've made those small changes in terms of removing the reference to building platforms in lieu of other mechanisms, such as no-build areas. And that is reflected in the Appendix 1 of the subdivision chapter. And I think that's all my supplementary. Thank you. I'll take questions now.
Thing that jumps out in the rules, you've changed the minimum lot size from the gross area, from the net area to the gross. So in the case of even in the residential zone where the minimum lot size is 500 and you've got a 50-metre long right-of-way, 3 metres wide, effectively you're creating lots of 350 and potentially less. Is that the intent?
So in response to that, there is the standard 2, which requires minimum lot dimensions. So that is to ensure that you still have a buildable area, even if you do lose some of your minimum lot size to your access way. One of the main drivers between changing from a gross area to from a net site area to a gross area is the existing historic subdivision pattern in Gore. Lots of the general residential sites are 806 metres squared due to the links and chains and old surveying mechanisms. And therefore, if we had a 400 metres squared net site area, it would struggle basically to get that infill development of rear lots. But yeah, standard 2 in the lot dimensions is to combat an area, a situation where we have long driveways and then no buildable area at the back.
So 15 by 15 is 225. So under the rules, you could have 2 buildings on it, 2 houses. A major residential building and a smaller one.
Yeah, you'd still need to, I guess, consider the bulk and location standards of the general residential zone, which requires outdoor space and permeability. And
would you be doing that as part of a subdivision consent?
Not necessarily if you can meet the the 15 by 15 standards.
At paragraph 143 on page 35, you make some changes to objective 5, and let me just bring up your additional one here. And you said for clarity, it should refer to section 229 rather than the list of things that were there before. And I was kind of thinking, for clarity, I haven't really clarified much by referring to 229. And so I went and had a look at 229 and thought, well, maybe we can include a list of things out of 229 that actually make it clear what we're talking about. But section 229 is so long that the list became unworkable. And then I thought maybe a footnote or an endnote in the chapter that actually had the content of 229. Just interested in your thoughts about how we can be a little bit more helpful.
Yes, I totally understand. I actually went through that exam process in terms of trying to incorporate 229 into the objective and giving up when it was too many words long. But I do consider we could help with that. I wonder if I'd have to check in terms of e-plans in the future, if that's the route that we're heading, whether we could link that through the e-plan. And in the interim, have something at the end of the chapter in terms of outlining section 229, which would follow because we reference. We reference section 230 at policy 11 as well. So we could do that.
Even before we get to the e-plan, the other thought occurred to me is that we have another file in the same way that we've got each of the chapters sitting on the website. We have another one that says this is not part of the district plan but is included on this page to be helpful, and then we could include section 229 and even some of the other guidance things that are in the different chapters, which we could quite easily just do. It doesn't need a submission to be helpful.
Yes, I agree, almost as if like an information only type layer on the GIS, similar thing. Yep, I agree with that, thank you.
go back to the one that fellow councillor raised in policy 5, ensure policy 5, ensure reverse sensitivity effects don't happen. No, sorry, on page 41, paragraph 183, is policy 7. And I'm looking, paragraph 183. So policy 7 is the way the subdivision is done. That was about number 5. In urban areas require access and provision for walking, cycling infrastructure through subdivision design. But equally, you want walking and cycling in rural areas. There's a walking and cycling track that goes part of the way along Reby Road, for example. Yet I don't see that picked up as part of the matters that are in the policy.
I consider the rural area is so expansive in this district. It may be that, it's a consideration for areas on the urban fringe, but if we're sort of way out in sort of deep farmland, I'm not sure if it really is a necessary consideration for subdivision in extreme rural areas. However, I do acknowledge that, there's an element of connectivity in terms of being on the fringe of the urban area. I guess we just need to consider what would be like the expectations of the policy if we included the rural area in there. Maybe we need to...
I'm thinking of the back in the rural chapters reports that referred to the 2017 cycling, what was it, the active recreation strategy. And it occurred to me that potentially that could be referenced in here as well, because that document is one that is referred to elsewhere in the plan. And it would make sense to me to actually flag it as part of this policy.
Okay, I will look at that. Yeah, so in my assessment, I've delved into that to a degree and talked about preserve, generally referring to maintaining something in its existing state, often to prevent any change or degradation. And protecting involves safeguarding something from harm, but it does not necessarily imply preventing all change. In my opinion, this is in relation to our rural zone minimum lot size. So we're preserving the high-class soils by not enabling minimum subdivision below 8 hectares. And in that regard, I think protect is important to have in there, because we're still enabling land uses to occur in the rural areas, i.e. primary production, buildings to assist primary production. And equally, it may be that, land is subdivided and changes hands, and it's still protected in that respect from the minimum lot size.
Given the first part of what you responded to, I'm wondering whether the policy might be preserves the high value soils and protects the productive capacity.
Yeah, that might read more logically than preserves and protects.
Yeah.
If those are two warring terms, in your opinion.
Go through these later hearings, I think the questioning is going to become more and more complex as we're looking back at earlier stuff as well. You've recommended the inclusion of number 10, that subdivision doesn't result in new vehicle access to a state highway. Yet the transport section requires a consent if you're a new connection. It's under the rule, subdivision resulting in no new lots in effect. So is that really a boundary alteration?
Yes, I think it might be helpful for me to explain why there's two rules that both look the same. It's actually in response to the National Planning Standards definition of boundary adjustment. So the definition of a boundary adjustment under National Planning Standards does not include how it talks about sites in a certain way. That means if you, a common, okay, let me rephrase this. So a common boundary adjustment attempt or application that we see is that you've got a huge farm and the surveyor will come out and they'll only survey this small chunk that you want to dispose of and effectively create two lots, but then the smaller lot will be amalgamated with the neighbouring farm or whoever it's going to be sold to. So technically speaking, it's a boundary adjustment because you've still got the same amount of titles at the end, but in reality, you have created an additional lot. So the definition of boundary adjustment under National Planning Standards would not allow that scenario because it just talks about not creating additional lots. So the reason for Rule 4 and the reference to titles is to enable that instance where you can effectively create an extra lot, but because you're amalgamating it at the same time, you still have the same number of titles. It is in response to that boundary adjustment definition and the practicalities of, because otherwise you have to survey the entire farm in order to do a strictly speaking boundary adjustment.
Okay, so if the only thing is they don't comply is they're creating a new access to the state highway, isn't it being a little bit mean, for the want of a better word, to jump straight to non-complying? Why not discretionary?
I don't think they would jump to non-compliant.
Yeah, it says look to Rule 7, which is non-compliant.
No, under Rule 7, you're restricted discretionary. And then if you... Oh, wait, hold on.
maybe the number hasn't been updated.
Yeah. Yeah, so if you don't meet that, you move to Rule 7, which is restricted discretionary. If you meet the standards, and then which is lot size, dimensions. Then if you don't meet the standards, then you're non-complying.
Okay.
So yeah, I included that access for the state highway because if I guess if you're doing a traditional boundary adjustment, then 9 times out of 10 all your accesses are existing because you're just shifting a boundary. Whereas because this rule allows you to sort of create a lot which you're then amalgamating with another site, there is the potential for needing a new access.
Okay.
So that's restricted discretionary.
No,
It's not.
just discretionary if it doesn't comply. And if it doesn't meet the standards, then it becomes non-compliant. So that's all from me on subdivision.
Thank you.
I just have a query. So the development contribution policy, you feel fits better with the council forming its own policy and not bringing it into the district plan. Can you explain why that would be?
Yes, I consider having a development contribution policy which sits outside of the district plan. It gives the council the ability to be more flexible, so those policies can be updated and amended with consultation through the council meetings and workshop, and you can actually set the dates that you would want to review them. Whereas once, if it was in the district plan, it would be a financial contributions chapter, and the standards of the amount of contributions and when and how it would be imposed would be fixed. You'd have to go for a full plan change proposal in order to change it. So a development contribution policy gives you a lot more flexibility, or gives the council more flexibility in terms of being able to be targeted in what they're actually requesting contributions from. You can update how the policies are applied to different areas and for what reasons. And it's more focused on sort of growth and additional development and what that then requires in terms of a contribution.
On page 13 of the earlier one, which is Rule 7. Yeah. Now, looking at paragraph 13, Hokanui Runanga lodged a generic submission to wherever reference to Mana Whenua 2.3 pops up in the plan. And this is one that was missed in terms of the way that it was coded. So as a result, your report hasn't commented on it. So I intend to deal with it by way of a consequential change arising from all the other ones.
Yes, that matter of discretion appears multiple times in the subdivision chapter. I had kind of anticipated that we need to land on somewhere with Hokanui Runanga, and then the reference needs to be consistent across the entire plan. So whilst, I haven't made a recommendation on it, my likely recommendation would be that we need to have consultation and agree on a specific wording. I think the intent will be the same, i.e. we'll be referring to that Mana Whenua chapter and the values that are included in that Mana Whenua chapter, but the exact wording will probably need to be tweaked and then made sure it's consistent across the plan.
Is that something that you're looking at providing feedback on when we have the hearing for the SASM chapter?
I will need to confirm with Courtney Bennett, but I would imagine so, yes. I think there's a few aspects like this through the plan that we need to make sure that we're consistent on at the end. And it might be a case of that's a section of the wrap-up hearing, just formally landing on that wording recommendation.
Yeah, because there's some things in the Mana Whenua chapter that are sitting in our draft decision where we've reached the point of saying until we've actually got the hearing and reports in front of us for SASM, we're not too sure how we should be dealing with it.
Yeah.
And while you as the advisors and the Hokanui Runanga have talkies and come up with something that meets equal needs, having regard to some of the submissions that we've got and that coming up as well, I think it's something that needs to be talked through in a bit more openness or at that hearing coming up.
Absolutely, yes. I'll make a note of that and ensure that this particular aspect in terms of that matter of discretion, because it does appear multiple times throughout the plan, so that probably will be quite an integral part of that discussion.
We'll adjourn for 10 minutes.